Thank you, Anjali. Well, I would like to begin by making some sort of a clarification, if I may. This is not a judgment that has been delivered by the Supreme Court. It's an interim order, right? And in the interim order, of course, they've said a few things, but it's not a final judgment. The second thing is that what the Supreme Court is looking at the moment is whether the case should be referred to a bench of 7 judges or should not be referred to a bench of 7 judges. You had mentioned that in the case of Kedarnath Singh, the Supreme Court had taken a decision, a bench of 5 judges of the Supreme Court had taken a decision to say that Section 124A of the IPC is constitutionally valid. Now, either that judgment is correct, in which case the Supreme Court may say, the 3 judges may say that, well, there's no need to refer it to 5 judges, to 7 judges, because we do not think there's anything wrong with that judgment. It is also possible that the Supreme Court may say, those 3 judges may say that, well, the matter requires to be looked at afresh, and therefore we would like to refer it to 7 judges and see whether the judgment is correct in the sense that Section 124A is constitutionally valid or not. So this is really the parameter of the judgment or the order that has been passed by the Supreme Court on 11th of May. Now, one of the things that the Supreme Court has said quite extensively, they have quoted from the affidavit of the Government of India. Well, there is a lot to say about the affidavit that has been filed by the Government of India, but I don't want to go into that at the moment, but only to explain really what is the order passed by the Supreme Court and what are the consequences or what are the ramifications of the order. It is important to note that the Supreme Court has recorded that the petitioners who approached the Supreme Court say that the law of sedition, that is Section 124A, is being misused. That is the case made out by the petitioners. The Attorney General for India, he also says that the law of sedition is being misused. And the example that he gave was about the threat to recite Hanuman Chalisa outside the Chief Minister's residence in Mumbai. So the petitioners and the Attorney General also say the same thing, that is, the law is being misused. The Government of India has not expressed any opinion one way or the other. They have not said that the law is being misused. They have not said that the law is being properly used. They've just held their cards, if I can say so, close to their chest without saying anything, except that we will re-examine and reconsider, and that re-examination and reconsideration will then be decided upon by the appropriate forum, and the appropriate forum in this case obviously is Parliament. But like I said, I don't want to go into the affidavit that has been filed by the government. What the Supreme Court has said, and I will just break up the order into a few directions or expectations. The Supreme Court has, after noting all this, they have said that we expect that the law will not be used by the governments. One of the reasons why they seem to have said this is because they have said that, well, it's a colonial law, and the Government of India has said it's a colonial law. 1,500 laws have been repealed, and we are going to reconsider and so on. So the Supreme Court said that we expect that in view of this, it will be appropriate not to use the law, which means effectively that please hold your hands, don't take any steps towards implementation of the law. The Supreme Court has also said, as a part of its directions, that we hope and expect that there will not be any registration of any FIRs for sedition. Number one. Number two, they have also said that investigations will not continue. Number three, they have said that the state, which is the central government or the state governments, will not take any coercive measures. So really, although they have said it's, we hope and expect, that's in a sense a polite way of telling the governments that, listen, please don't do this. Please don't register FIRs. Please don't continue with investigations, and please don't take coercive measures. Of course, the Supreme Court could have been more positive and said that, forget about hope and expect, we direct in this manner. But like I said, they still haven't decided whether the law is constitutionally valid or it is not valid. The Supreme Court has also said that in the cases that are pending and which have already been filed, the accused person can approach the court for appropriate relief. Now, frankly, that's not saying much, because if a person has been accused of an offense, that person can always approach the appropriate court for relief. So the Supreme Court has not really said very much by saying that, you can approach the court for relief, because that is in any case the entitlement or the right of any accused person. But they have added to that by saying that when that accused person approaches the court for relief, then that concerned court will consider the order that has been passed. That is the order that has been passed on 11th of May, and will also consider the view expressed by the central government, namely that this is a colonial law and that 1,500 laws have been repealed. So, in a sense, giving a hint to the court wherever an application is filed, that please look at it, in a more liberal manner than you have been doing in the past, because of these factors which have come out during the course of the hearing and which have been mentioned by the government of India in its affidavit. So, to this extent, I think it's positive that a person can approach a court, and the courts have been sort of hinted at that please be a little liberal when you're dealing with such cases. What about the future? For the future, now this is a bit of a problem. For the future, the Supreme Court has said that trials, appeals, and proceedings will be kept in abeyance. So, in one way, it is good because the trial will not, continue. It is also good that an appeal will not continue and any other proceedings will not continue. But at the same time, it can have a damaging effect in the sense that a person is completely innocent, right? And the allegation of sedition and a case or an FIR or a charge sheet has been filed, just because the prosecution thinks that sedition has been committed. Now that person will have to wait for the trial to conclude. But if there's a stay, the trial will never conclude, until the Supreme Court lifts the stay. Similarly, a person who has been convicted, that person has filed an appeal. I would assume that person has filed an appeal, but then the hearing will not go on. So this person will not be able to prove his or her innocence. So in that sense, the direction that has been given by the Supreme Court that trials will not proceed, appeals will not proceed, I don't think that that's good. They should have given the option to the accused person. What does he or she want? Should the trial go on? Because then that person will be able to prove that I'm innocent. Should the appeal be, heard? That will again give an opportunity to the accused person to prove that I'm innocent. So this is, a bit of a problem in that sense. Now, one thing which I have not been able to, understand in the order passed by the Supreme Court is in the directions that they've given in paragraph 8E. In paragraph 8E, they have referred to some proposed directives which are proposed to be issued by the government of India. I don't know what those directives are. They've not given any indication of what those directives are. They've just referred to some proposed directives. So it would be worth knowing what those directives are, what do they say, what are the implications of those directives. Here, I think it's a bit of a letdown in the sense that we don't know as citizens what are the proposed directives. Now, what I find which is missing from the order passed by the Supreme Court is what I would refer to as collateral damage. In one sense, a trial not proceeding, the person says, I'm completely innocent, you state the trial, that's a part of collateral damage, but I'm on a different issue altogether. One is that, I can give you the example of this young environmental activist from Bengaluru, Disha Ravi. She was keen to go and attend COP26. It appears that about 3 months prior to her scheduled departure, she applied for a passport. And no steps were taken to issue the passport. Normally, it should not take 3 months. But here, because she was charged with sedition, I'm assuming that because she was charged with sedition, they did not process her passport. So you will have hundreds of people against whom allegations of sedition have been made and FIR has been filed and cases pending in the court. Now, these people, if they want to go abroad, their passport will not be processed. And it's not as if they're going abroad for tourism or something. Some of them may be going abroad for studies, for higher studies, young students, young persons. They will not be given a passport, right? There may be some people who might be applying for a job, a government job. Now, in that application for a government job, one of the columns usually is there any case pending against you? And the person says, yes, there's a case pending against me and it's a case of sedition. That person will never be selected. I mean, they will just reject the application. That, listen, we can't, think of appointing a person who is accused of sedition. It's a very, very serious offense. So that's the end of it. So this collateral damage, to persons who have been at the receiving end of the misuse of the law of sedition or the abuse of the law of sedition, I think that is something which is very, very serious. And unfortunately, I think the Supreme Court has not looked into this aspect, because it can have a very serious impact on students wanting to go abroad for study, other persons who want to go abroad for some other work, like Disha Ravi, for example, I had mentioned, or persons who want to apply for jobs. It could also happen, by the way, in the private sector. If somebody says, listen, I've got a case of sedition, that employer may say, sorry, I'm not going to employ you. It's a very serious offense. So, and again, one never knows, if the law is being misused, then the police might come to the employer's house. Oh, you've employed a person who's, committed sedition. So you must be also part of that conspiracy and so on. So these are some of the problems. The other thing is, it's good in one way that investigations have been halted, right? Which means that the charge sheet cannot be filed. If a charge sheet cannot be filed, then the person who is in custody and who's not been given bail will be entitled to default bail. So in that sense, it's good for that person that, the investigations have been halted, because then that person will be entitled to default bail. Status quo order, I don't think is good, generally speaking, in cases of persons who've been victimized or who are, at the receiving end of some political vendetta or some other kind of, vendetta against whom, cases of sedition have been filed. The last thing that I would like to say, and which again is a matter of very serious concern, is that there is a parallel provision in the Unlawful Activities Prevention Act under the UAPA. Section 8 Section 13 read with the definition of unlawful activity. Now, unlawful activity under the UAPA is defined as causing or is intended to cause disaffection against India. This is the only difference, disaffection against India. Now, in sedition, it is disaffection towards the government, right? That's the only difference. In sedition, it's against the government. Unlawful activity, it's against India. Now, really, the government represents India, right? It's not that the government is one and India is another entity altogether. The government represents India, or India is represented by the government. So, okay, now under the section 124A, there are some explanations which say that the following will not be sedition. All right, so you can come under one of those explanations and you will not be, accused of sedition. But there is no such explanation under the UAPA. So what is disaffection? Disaffection has been explained, like I said, under 124A. But what is disaffection has not been explained under UAPA. So really anything which the police feels or the state government feels is disaffection, without any explanation being there in the law, they can say that, well, this person has committed an unlawful activity and therefore this person should be arrested and put behind bars for an offense of unlawful activity under the UAPA. Now that is very dangerous. Okay, because getting bail under the UAPA is a different story altogether. Under sedition, people have accusations of sedition, people have got bail. But getting bail under UAPA is very tough. So really, I don't know what the government will do. Will they reconsider, re-examine this, that, and the other? But if the government wants to continue in this policy of, arresting people, scaring them, stopping dissent, this, that, and the other, the easiest thing to do is, remove section 124A from the IPC and start arresting people under the UAPA. Effectively, people will then be jumping from the frying pan to the fire. I think this is something of very serious concern. So two serious concerns. One is the collateral damage, which I have explained. And the other one is this, possible use of UAPA. Yes, that's all that I have to say on this subject. Thank you very much.